right, and welcome to MLS God of Law. With me today, the great, the powerful Steve Gosney. Welcome, sir.
Powerful. Hey, I like that.
How you doing? How you been?
Very good, very good. Thank you for the invite. I've been actually on hiatus again
Yeah,
for
I
a
know.
number of
Both
reasons.
you and I, right? Yeah.
Yeah, oh yeah, you involuntarily, right? No, I'm just gonna but I've been, ducking in and out when people remember that I exist and I
Right.
have something to say. So
By
thank you
the
for the
way,
invite.
I saw you on Pearl yesterday.
Yes, how about
That
that?
was
Well,
a great conversation. I like that a lot.
yeah,
Um,
I mean, she's interesting. I've been doing a lot. I did a lot of research for my Death Penalty Desires book, and I have a son who's going to be entering the dating market. So I'm concerned about the whole state of affairs between men and women. And of course, I wrote Prepare, the Handbook for
right.
Individual Freedom, and so I was watching this Pearl, who's kind of an interesting alternative take. I listened to alternative voices and has a lot of wisdom to share. And she was doing this call-in show, and I'm like, well, you know what? I'm going to click there and see if I can get on. And they put me on there, and I got to put a little plug in for Christianity and Catholicism. So
Yeah, she wondered if there's any road back for Catholicism. Which was no, it was a good conversation. I like her take on. I like that she stirs the conversation. Pearl
right.
does. She's not afraid to just sort of mix it up, and she gets a lot of hate online. But I believe her conversations. I might not agree with her opinions, but her conversations are great, and I like watching.
But
It was
but
just good to
it's
see
not
you.
even. We're talking about Pearl, which is pearly things, and
Yeah,
actually, I tried to actually when I was in the private chat, I said, I want to interview you because I'd love to have her come on and interview on my channel. I
I
wanted.
reached I
Would that be
reached out to her. You're going to be my way in because I'd reached out to her like a year ago. I wanted to bring her on and have like do Legos or just interview her too. So,
But I
um,
think that the thing is that what she does is she observes and she says things the way she sees it, and I think she's honest in that. And I don't really know, she has opinions, but it's funny because I think a lot of the blowback comes from people rejecting her view of the way she sees reality. And I think she's being honest about how she sees things. Now, people criticize everybody on the internet if you have an opinion, but yeah.
yeah, everyone's got an opinion on the internet. I found that out. Um, but we're here to talk about the First Amendment. And so if you guys have been watching me at all, I covered the Zachariah Anderson case. And just recently, Solomon Anderson, Zach's brother, and myself did a series called Barely Interesting, where we would follow up with, we restreamed the Zachariah Anderson trial, and we would follow up with that. During the first Steve joined us for one of them, actually. And so during the very first one, Solomon had brought up Oliver Wendell Holmes and some quotes from him that made it into a Harvard Law Review. And so that got me down the road of Oliver Wendell Holmes in sort of a rabbit hole sort of thing. And he was a justice from 1902 to 1932. I think one of the longest serving justices in history. And he made some strides in 19 teens with regard to the First Amendment, specifically the right to free speech. And what's interesting about when I was doing my research, going down this little bit of rabbit hole, is that it didn't start the way we think it does, right? So you've heard maybe uncivil law talk about the right to free free speech, right? And he talks about it being a definite article as opposed to an indefinite article, which means that there's a specific right that they're talking about when they frame the First Amendment. It's not all the speech, it's a particular type of speech that we have the freedom of. And if you are an originalist, you might not like this approach. And now, if you're a textualist, like I think uncivil is, you're going to be fine with this approach. But if you're looking at the original concept, it stems from England. All of our common law, our whole legal system stems from England. And this guy was a justice in England, and a lot of what he had to say about the freedom of speech is what the founders had envisioned when they were constructing the First Amendment. Steve, you know this guy?
Oliver Wendell Holmes, or this is
No,
Blackstone.
this guy. This is Blackstone.
Blackstone, yeah, and he wrote Blackstone's commentaries, which, just so people know that, like you said, common law of England became part of the United States tradition because of the original 13 colonies' roots in England. And so Blackstone wrote what they called commentaries, which was commentaries on the laws of England. And that was case reporting, and he kind of created this idea of the English common law. And for the longest time in England, the commentaries that he wrote was the basis of law education in England. So in order to become a lawyer, and everybody would refer to Blackstone's commentaries. So he's a very influential figure in American and English common law history, because he was the guy that you studied, and his summaries on the cases were what was important. So when you read, the rule in Shelley's case, it was because Blackstone put that in his commentaries.
So this is the guy that we have to thank for a lot of the fundamental principles, legal principles that we have in this country today. And so that's why I bring him up. But he also had a lot of writings and opinions on freedom of speech. Now, what existed at the time, this is 1723 to 1780, was the concept of freedom of speech in England at the time, and the United States before it was the United States, was you had the right to petition the government without asking permission first. That was the big thing. The freedom of speech was the right to speak to the government, speak your mind without having to ask permission. But there is nothing against the government punishing you if you stepped out of line. If your speech was not liked by the powers that be, they absolutely could and would punish you for it. Especially if it was an issue of national importance, like a war or something like that. Absolutely, they would, and they did punish you. But you could still do it. You just might get in trouble. So when we're talking about the freedom of speech in the First Amendment, that's what we're talking about. Not the government being unable to punish you, but your ability to speak your mind, your truth, your opinions to the government without having to ask permission.
Well, and I'm gonna narrow that a little bit, because I want to make sure we're and this is an extremely complicated subject. And as far as constitutional law goes, First Amendment law is the mountaintop of constitutional law. So so it's easy. A lot of people like to come up with knee-jerk statements like, I'm a First Amendment absolutist, right? But they are sadly mistaken. That is not the state of First Amendment law. To understand it, it takes the greatest minds to fully. It's a very, very complex subject. All right. So with that being said, and putting my hat in hand that I'm just a little public defender here in Florida, my understanding too is that a lot of the ideas of freedom of speech came out of the Houses of Parliament, and specifically the House of Commons' ability to address and to speak their mind freely in the well of the House of Commons against the king. So they basically said, we are sovereign. We should be able to say what we want when we step to that lectern and speak as part of this common law body. And that is and to the sovereign, meaning the king. So now we've expanded that obviously to.
And it, by the way, it also, I mean, its origins do come from the Magna Carta as well, the right to petition the king, in that regard. So it does have its origins in the Magna Carta, which is what, 1680 something. I can't remember exactly what that is. So you're right. Yeah, you're narrowing it in that it's the right to petition the king in this sense.
And also who gets to make the speaking, because the who was, I believe, there was a much more, the limitation was really to the MPs, the people, the members of parliament. So, and there's a lot of, I'm just talking about history. Where does this idea of freedom of speech come from? And if we, and we're starting way back pre-United States, pre-Constitution, we're talking about rights that were established in England so that as a battle between the parliamentarians and the monarchy. So that's the roots of free speech generally in America. Now we've evolved quite a ways from that point, but let's put that starting point there back in Blackstone's commentaries.
No, exactly. And then so when the founders didn't just say in the First Amendment the right to free speech. Congress shall pass no law which would, the right to free speech, but they also put the free press in there to allow commoners and everyone to petition the government, or at least say what they want to say in the presses. But again, it didn't prevent the government from exacting some sort of punishment against you for your speech. And when we're going all the way up into the 1900s, and it really wasn't until, and it didn't even really happen with this gentleman, but Oliver Wendell Holmes was the justice, like I said, from 1902 to 1932. He sat on the Supreme Court. When he first sat on the Supreme Court, that was still the fundamental understanding of the right to free speech. The government could still punish you for your speech. But what's interesting about this gentleman, and the reason why I like him so much, and if you guys don't know anything about him, you need to go look him up. He wasn't afraid to be wrong. And so in 1917, the government passes the Espionage Act. And then in 1918, they passed the Sedition Act. And both of these acts basically have the same thing. Don't talk bad about the government. It curtails your freedom of speech. We're in the middle of a war. You can't petition the government, or not petition the government. You can't talk bad or encourage others to. Well, we'll get into the details with it, but we have this case from 1919, and these individuals, they were socialists, and they were dropping leaflets declaring that the draft was in violation of the 13th Amendment against involuntary servitude. And so that was their petition. And they were charged criminally under the Sedition Act and the Espionage Act. Well, not the Espionage Act. They were charged under the Sedition Act for talking bad about the government. Okay. So now the question is, we have this frame of mind that you can say whatever you want to say without asking the government's permission, but the government can punish you. And we have these acts, which sound horrible today, right? The Sedition Act, which was passed in 1918. The act, let's see, it's extended the Espionage Act to cover broader range of offenses, notably speech and expressions of opinion that cast the government or the war effort in a negative light. Okay, imagine them passing a law today that says you can't talk about how bad the war on terrorism is. That would never fly. I don't care what branch.
Well, I'm going to push back against that. You say that, but we are in fact punishing speech in this country. I think that we are living in a post-constitutional situation. I mean, and I've expressed my personal opinion on this. So
let me rephrase that then. Let me cast this in a different light. Let me be more on the nose. Okay. Because I know what you're talking about, and there's a lot of things going on with the government. But imagine them actually passing a law saying it is illegal for you to criticize any war effort that the U.S. government is engaged in. Blanket statement, that is it. We passed that law. Do you think that would be cool with the people? I don't know. I still think there'd be a lot of pushback. But at the time,
there'd be pushback, but then people will sit in prison, federal prison, while it works its way up to the U.S. Supreme Court. I gotta say, I'm pretty cynical on this. But you've leaped ahead to the present day crisis that we are facing. Can we flesh out the First Amendment a little bit more before we destroy it in a bonfire of leftist vanity?
Sure. Sure. Go ahead.
Okay. So if you know that the First Amendment has packed into it quite a number of freedoms, including the freedom of religion. But if we unpack the ones that relate to speech specifically, we have the free speech context. We also have the right to press, and we also have the right to petition. Those are three independent and distinct things. So, and it's a mistake to conflate those. In fact, one of my U.S. Supreme Court cert petitions that was denied was a petition for, was a writ of cert to the U.S. Supreme Court because I had a client who videotaped a police, or audio taped, let's say, videotaped and audio taped a police officer in the performance of his duties, who was complaining about his treatment by the police agency, took the audio videotape, attached it to a complaint, a petition to the police department saying, I was abused by this police officer. And the police agency took that document and that complaint, turned it around and charged my client criminally for recording the cop without his permission. And my position was that the First Amendment, the right of petition, absolutely protects him because that was a petition for a redress of grievances. Now, of course, he was convicted and the Supreme Court turned him down. Now he's convicted of a misdemeanor. He was originally charged with 2 felonies. I won at jury trial and got convicted of 1 second-degree misdemeanor, which I took to the U.S. Supreme Court. But the fact is that the right of petition there is a separate and distinct and more absolute provision of the First Amendment. Now, let's can I talk a little bit more about to the people who say they're First Amendment absolutists, because that's a big thing that like to people to say. And I will say that I am not an absolutist. I am very pro First Amendment. I'm very pro individual rights. And I think I wrote a book on that issue about individual rights and the right to individual freedom. However, speech is criminalized in many contexts. And it is, and let's just list some things. For example, conspiracies. Conspiracies are agreements to commit a criminal act. So if I conspire with somebody to commit first-degree murder, that is conspiracy to commit first-degree murder. The act of speaking and agreement is criminalized in a very serious way. Similarly, antitrust law. Antitrust is conspiring to price fix. That is criminalized. There are lots of substance, like the Rosenbergs, who communicated plans for nuclear weapons to communists, were executed for treason for basically communicating.
Yeah, but what year was that?
Well, that was in the Cold War. That was in the 20th century.
Yeah,
post World War II.
I know we're still making progress here too.
But would you say that shouldn't be criminalized? We should allow people to transmit nuclear secrets to terrorist organizations, for example, and that should be completely fine? Or is there something to be said for some restrictions in that manner?
Well, and that's the debate that Oliver Wendell Holmes had with himself in very 2 distinct cases. Because what I wanted to really address here was how, for the first time, again, under everything that you said is perfectly fine for the government to do, absolutely perfectly fine up until around 1919. There was no issue with it whatsoever. It was being done all the time. The first Sedition Act was passed in 1793 or something like that. I mean, it was like the 3rd law that Congress passed was, don't talk bad about the government, right? So this has been around. The founders passed a law very similar to the Sedition Act that was enacted in 1918, right? So it was perfectly fine to do. Everything that you said is perfectly fine for the government to do. There's nothing wrong with it. There's nothing unconstitutional. When you frame the issue as you can speak, but you're still going to get punished for it if it creates a situation where it harms the government or could do damage to the government, such as, like you said, selling nuclear secrets and things like that. But nobody questioned it. Nobody questioned it at all and said, there's no line here. There's no balancing act or anything like that until Oliver Wendell Holmes in 1919. But what's most interesting to me is that this case. So this is Shenik. Is how you say it?
I think it's Shank, but I'm not.
Yeah. Okay. V. U.S. All right. So this case was decided on March 3rd, 1919. Oliver Wendell Holmes wrote the opinion, and he confirmed the conviction of these two individuals for in violation of the Espionage and Sedition Act, because they were dropping leaflets declaring that the draft was a violation of the 13th Amendment and encouraged people to disobey the draft orders. Okay, this is during World War I. So he confirms, or he affirms the lower court's decision on this particular case. Then, 7 months later, November 10th, 1919, we have a similar case where these two Russian citizens were saying, were protesting the U.S. government's involvement in the Russian Revolution. They're not anti First World War stuff. They're pro that, but they didn't like the U.S. government getting involved in Russia's internal affairs. So they're protesting that, and they're charged as well. Now, interesting. 7 months later, Oliver Wendell Holmes has a change of heart. Now, he's in the minority. The court upholds their conviction, but he writes the dissent. And he writes the dissent having a change of mind. In these 7 months, he's reading a lot. If you don't know about Oliver Wendell Holmes, he reads a lot and he talks to people. And he's talking to a bunch of, mind you, he's a conservative. He fought in the Civil War. He's die-in-the-wall kind of conservative view, but he changes his mind in 7 months and actually writes a dissent in this case. And it's the first time that there's anything from the U.S. Supreme Court that says maybe we should step back and not punish people for exercising their freedom of speech. And I have a short little video of his of a portion of his dissent, and he doesn't win the day here, but this sort of sets up the framework. And I find these words, and he has a way with words, and that's why I'm not reading them, but I'm going to have AI read them.
Persecution for the expression of opinions seems to me perfectly logical. If you have no doubt of your premises or your power and want a certain result with all your heart, you naturally express your wishes in law and sweep away all opposition. To allow opposition by speech seems to indicate that you think the speech impotent, as when a man says that he has squared the circle, or that you do not care wholeheartedly for the result, or that you doubt either your power or your premise. But when men have realized that time has upset many fighting faiths, they may come to believe even more than they believe the very foundations of their own conduct, that the ultimate good desired is better reached by free trade in ideas, that the best test of truth is the power of the thought to get itself accepted in the competition of the market, and that truth is the only ground upon which their wishes safely can be carried out. That, at any rate, is the theory of our Constitution. It is an experiment, as all life is an experiment. Every year, if not every day, we have to wager our salvation upon some prophecy based upon imperfect knowledge. While that experiment is part of our system, I think that we should be eternally vigilant against attempts to check the expression of opinions that we loathe and believe to be fraught with death. Oliver Wendell Holmes, November 10th, 1919.
So I really like that quote. Now, he goes on to say, in certain extents, still, there is an obligation on the government to check freedom of speech and punish people, such as if they're giving away, military secrets and things like that, if it's at the time of war and things. But I love the way he frames that truth can only be gotten from the free exchange of ideas. And
this is, I would say, the more modern concept that we now adopt, and that people, when they say free speech absolutists, and so the next step, which you're referring to here, is called the marketplace of ideas, which is that there is and conservatives, generally being free market, pro-free market, are thinking of the body politic, the politic of our debates, the speech that revolve around in free speech, are there as an error correction device. So, and the idea is that truth will rise to the surface. Falsity will be exposed by over time by free discussion. So there's the highest peak, and the courts actually have distinguished. There is a ranking of quality of speech. The top of that pyramid is political speech. Political speech being the most important to a free society, because, for example, in a dictatorship, they have somebody at the top. They make a decision, and that decision is wrong. There's no error correction. You have to kill the top guy, right? You got to kill the tyrant. Whereas opposed to, we have elections, we have to have a robust political debate. So this idea of the marketplace of ideas, and is this an idea that is worthy in the marketplace of ideas, is a modern concept that enriches the First Amendment to the point that now there's let's talk about other levels of speech that are less protected. The step below political speech would be commercial speech that, advertising, lawyers who advertise, for example, right, who are the ones but billboards and cigarette ads. And then you have the next step below that, which is considered, I would say, like common speech, or maybe even below that, obscenity, which is the lowbrow, that doesn't have any kind of value to the marketplace of ideas necessarily. So the courts see these different gradations and see different values on levels of speech. So when Holmes is talking about, and what we really are talking about when we say I'm a free speech absolutist, is I should be able to discuss political issues in an unhinged and free way on the internet, in the public forum, in print, in radio, in every form. When we're discussing political direction of the country and political and freedoms and all of these things, I should not even be punished for that, because it enriches the marketplace of ideas.
Yeah, and it is very much the modern idea behind the freedom of speech concept that we have. This, but it's such a change from the way the U.S. government judges common law for years, and you can hear it though in that statement, and that's the first time ever that a Supreme Court justice, or anyone really, has expressed those ideas that we need this. And it sounds so modern to us, and it wasn't really that long ago. It was 105 years ago. We've come a long way to this concept. What I find sort of, if talking in broad strokes, Steve, we're not getting into the detail, but broad strokes, right? So when the Constitution was written and the First Amendment was written, the idea that you could petition the government but still get punished for it, or you could freely speak without permission but potentially still get punished. Today, you kind of need to ask permission to some extent, especially if you want to do like a protest or something. You need to get a permit, but you can't be punished for it. And so those two things have switched, I feel.
Well, and there's
to some extent,
there's also this idea that for the longest time, the Bill of Rights only applied to federal government action.
That's true.
After the Civil War, most of those rights, except one, has been incorporated, though it's in practicality, all the Bill of Rights are incorporated against the states. So now our Bill of Rights applies against the federal government and the states. And then you say, but the problem is, what we're dealing with now is corporate power and institutional power that is being bypassed. So the state is being bypassed, or perhaps even the state is colluding and working its way around these constitutional limitations by working hand in hand with political allies who control our media institutions to shut down speech that they don't like, or to marginalize speech that they don't like. And so
let's break that down. Okay. So I know a lot of people don't like the idea behind corporations having a right to free speech, right? People get icky when they hear about this, but I want to break it down this way. Let's say Steve and I and the people all watching, we all think the exact same way about something. But we're just one voice, right? Individually, we're just one person, but we can collectively decide that we're going to get together and make our voices a little louder. And that's going to be because we can pool resources. We can hire somebody to go lobby a senator. We can run commercial advertisements because we're stronger together. We have a louder voice together. Should we be prevented from doing that because now we're some sort of commercial entity?
Right. Well,
I don't think so.
This is the there's two concepts here. That, like I said, this is a very complex issue. So there's no easy answers here, but we're touching on some of the problems and some of the rays of light that illuminate the issue. One of them is, let's take our freedom of speech ideas and our freedom of press ideas and apply them to a corporation. All right. Or let's just say an association. Well, we do have something called freedom of association. So in addition to the individual right to speak, we also have the right to associate with each other. So that means that we can get together if we have a common interest and form a group, form an organization. Now, what is the nature of that group? Is it a corporation or is it a partnership? Right. And so as you studied, organizations and business organizations, if we don't have any agreement at all, and we get together, the three of us, let's say, that's a partnership. Now we can formalize that and incorporate it, but it's basically the same thing. It's just an entity that we call, MLS Ghazni Partnership. And then we say MLS Ghazni Partnership LLC. Now it's a corporate form. Do we somehow lose our right to speak? Now, the other concept I want to add to that, aside from freedom of association, is the idea that money is speech. And this is one of those, again, another one of those left-wing bugaboos that they hate because they say, well, that corporations speaking and that money is somehow there should be limitations on financial contributions because money is the voice, because money is what it takes to amplify a person's voice. So there is this idea that money is equal to speech. Now, that is the current state of the law in the constitutional law, at least federal law, that money is speech and corporations do have the right to free speech, even though corporations are an artificial person, not a real person. That is where we are. And I think it's not so much that is what the founding fathers decided, or that's the originalist idea. I think instead it's because there's no better way to dissect the rabbit, right? I mean, the fact is that money is speech. Now, when you say, how are you going to say that it's not? What is the rule that can somehow separate dollars from being speech? And I don't think there is a good rule. So we devolve into the fact that money is speech.
Yeah. Well, I mean, money buys you airtime. Money buys you, this whole operation right here that you and I are doing is not free. We need equipment to do it. We need subscriptions to do it and things like that.
Or you can just lose money like I
Well, yeah. But you got to spend money to make money, Steve. But money is speech in that regard. And just like I said, with our little scenario, if everyone on this, in the chat right now wanted to get together and say one thing to the government, we should have the right to associate, pool our resources, and do it. And so that's why money is speech, and all that makes sense.
It's actually a right of the individual, the common people. Against you, people think, well, this is a big money thing. The big money people already have the speech. But what if the common people want to get together and voice their opinion? So I've got 1 million people with $1 or one billionaire that can contribute $1 million. Well, the common people can contribute their $1 and have the same voice as the billionaire. So in fact, when you combine money with the freedom of association and the ability to buy, the populace can speak when individually we don't have a voice.
Right, exactly. That's kind of the idea behind the whole corporate. Someone said in the chat, Walmart has feelings too. Remember, Walmart has a board and directors, and those are people, and those people have feelings, right? So, we could talk about faceless, nameless corporations, but there's always people behind them.
But see,
Some
and
like
this is
to
where
run
we have a
autonomously.
lot of challenges in our society, and one of them is that there is no accountability to those in leadership positions of our major institutions, including corporations, to the stockholders, to the people that run them. Instead, they get into these positions of power and of influence and are unconcerned about their responsibilities to their shareholders, their institutions, or to the truth. Instead, they want to show off to their brethren at that elite level. And so, like Disney, for example, Disney keeps making flop after flop after flop after flop movie because they're injecting political correctness into their movie making. Well, in any sane world, that board of directors would have booted a long time ago, and we would have a Disney that better reflects the marketplace. But because there is no accountability on corporate boards, they keep getting away with it. And I forget who said it, but there was somebody who said there's a lot of ruin in a country. And that's what we're seeing. We are very wealthy, and we have a long way to fall. And so you would say these parasitical leadership elites, self-appointed elites, that are parasiting the people and the country. And how much exactly can we take? I don't know, but it's a major problem in our society.
No, I agree. It is a problem. So you had alluded to it. Well, maybe didn't allude to it. You hit it on the nose about the idea that government is telling some of these corporations which speech they should allow on their platforms and which speech they shouldn't. Do you think the government has a place to do that? Do you think that should be allowed?
Well, it's a broad question. We'd have to get specific on what we're talking about.
Well, right now, okay, so let's say this. Facebook was told and I think Twitter at one point, but we'll just deal with Facebook, was told to take down certain things regarding the vid.
Regarding the what?
Well, I'll just say COVID. I'm not monetized. So they were told to take down certain things about COVID. And so now the government's being challenged on that and wondering, I think there's some lawsuits involved with that. But do you think the government should be allowed to tell private corporations to take things down?
Right. Well, in that case, absolutely not, because science itself is questioning. Science itself requires the marketplace of ideas. The fact that there is settled science is not a scientific statement. There is science, and science is not settled. Science requires people to test hypotheses. So for the government to then put its finger on the scales of one side of some scientific debate or scientific question, which is what medicine is absolutely wrong. Now, the problem is there's no accountability. Like I said, it's not that these elites are doing this. It's that there's no consequence for the misbehavior. There is nobody that has been sanctioned anywhere for any of these wrong decisions. And like I said, it's a scam. So we get scammed over and over again. And I think that part of the problem is it's the capture of the institutions. Can I go back one though? And since we're talking First Amendment, I want to add one more piece to the puzzle.
Sure.
Because we went from common law, went to Wendell Holmes. The other big decision that's overriding a lot of this is New York Times v. Sullivan.
Yes.
New York Times v. Sullivan was the absence of malice standard, the actual malice standard in defamation law, which came out in the 60s. That is a very important understanding. My son's playing computer games. So that's a very important decision to understand defamation law. Now, what that means is, and let me just give you a little context to this case, because it's a really interesting case, and it's a very important case to understand, and I have a lot of opinions on it. During the Martin Luther King civil rights deals, they were marching in southern cities like Alabama, right? And then what happened was the New York Times published an ad, and the ad said something about the sheriff, Sullivan, down in Alabama that was factually wrong. That was something minor. It was like, he was marching on Tuesday and said it was Wednesday or something. It was really that trivial, but it was actually false, and it was provably false. So Alabama, the sheriff sued the Southern Poverty Law Center, or the Martin Luther King organization, right? In Alabama, got an Alabama jury who don't like those uppity Martin Luther King people, and they came down with like a multi-million-dollar judgment against the New York Times for running an actually false ad. Now, so New York Times v. Sullivan then came down and said, we're not going to allow this kind of state attack on their political opponents. Not that this has any relevance to today. I'm just saying they came down very hard and basically eviscerated defamation law by, there's defamation, there's elements, and there's this tort of defamation, and then there's the actual malice standard. And that means that in order to find liability, the jury has to find not only was it false, but that they knew it was false when they published it, and they did it with actual malice. Now, and so it's an extremely high bar to prove somebody knew something was false and published it anyway. Now, with that being said, it was really a civil rights era case. And what the underlying message of that was that the marketplace of ideas is tolerant to false statements. False statements are allowed in the marketplace of ideas. Now, I'm not certain that that's a good thing. I'm not certain that the repercussions of New York Times v. Sullivan were fully comprehended, because instead you could look at New York Times v. Sullivan as an excessive fines case. It was actually false, but there was no damages.
Right.
And they could have addressed it that way. But instead, the court, I think, got impatient, it was activist judiciary, said, we're just going to rewrite this defamation law and give people no opportunity to correct falsehoods about themselves in the court system. There's no way, if somebody lies about you, that you can correct that in the marketplace of ideas, absent overcoming knowing that they said it intentionally false. And so therefore we have a lot of lies that are perpetrated throughout the system, and that is repercussed. And I'm not certain that truth does survive in the marketplace of ideas in the face of overwhelming lies.
That's an interesting perspective of New York Times versus Sullivan, because most of the people see it as a championship case for the right to freedom of the press, essentially, and anti-defamation. And I can offer an opinion and I can be wrong and it's still okay. But to say that what you're doing is perpetrating a system that allows lies and mistruths to be presented into the marketplace of debate and thought is interesting. I've never heard from that perspective before.
And that case is in 1964. So,
yes.
And it was a civil rights case. But when people think of it, they don't think of it as a civil rights case. It's a defamation case that establishes actual malice. And it goes to the free speech absolutist argument that I can say whatever I want, true or false, and throw that in the marketplace and it'll sort itself out. Well, I think that is a consequence of an activist course. I really do think New York Times v. Sullivan is ripe for overturning. To maybe
I haven't read it in a while, but wasn't one of the issues that the target of the untruth statement was a public figure, and that's why it required the malice?
Right. That was, well, it was New York Times v. Sullivan. Exactly.
Yeah.
Sullivan was the sheriff in Alabama.
So he was a public figure, and so therefore you needed to prove actual malice as opposed to just a wrong statement or a mistruth. Which,
however, with the internet, everybody's a public figure now. Am I a public figure? I mean, really?
Yeah. I mean,
it's like if I'm in a public, everybody's a public figure. Just by, it is funny. This just magically transforms because we say you're a public figure. And now it's like, well, people will out you. You defend yourself in public. Now you're a public figure.
That's, the test to be a public figure. There's a whole case law or a whole set of case laws regarding who is and who isn't a public figure. And usually it's the voluntary approach. Like if you voluntarily put yourself out there into the public, it doesn't even matter how big the public is that you're putting yourself out into, then you could be considered a public figure for the purposes of defamation. If you're dragged into the public involuntarily, however, that's a little different. So you get things
But
like where
think about the
people are
money it takes civilly to sort that out. So now we're
right.
talking about barriers to entry. So, you
Yeah.
know, if you come in with a defamation claim, they're going to say, now, oh, are you a public figure or not? Now that's something we got to litigate. How much is that going to cost? The costs to remedy this are so huge. Now, I got to say, one of the best and one of the hardest classes I've ever had in my entire life was Professor Brian Murchison at Washington and Lee Law School. Communications law is a 5-hour class on the First Amendment. And Brian Murchison is legendary at Washington and Lee as a First Amendment scholar, and was one of the greatest professors I've ever experienced. And he's still up there, I think. I think he's still teaching. He's well respected. Anyway, one of his proposals, one of his ideas, it's a very difficult problem. One of his ideas was to have an alternative system for truth determination through the courts that bypasses the damages. Because if you're looking for money, that's one thing. But what if you just want your reputation back? Have a system by which you can have a declaratory judgment type thing about issues of fact of defamation that bypass all of the penalties, because what happens is it becomes such a high stakes game to determine truth or falsity, and the money, like the damages to the police commissioner in Montgomery, Alabama, Mr. Sullivan, were de minimis. There was no he had no damages.
Can I bring a declaratory action? I feel like I can bring, at least in Michigan, I feel like I could craft a declaratory action to ask the court to find that this statement was false without actually seeking any damages. I feel like I could craft that under Michigan law. Is that not something that's generally able to do? I mean,
Well,
because
you're
we
the
have
civil
procedure.
guy. I'm a criminal guy.
I feel like I could, because I bring declaratory actions all the time. I do, Judge, tell us what this is. Tell us what this says. Tell us how, So can I say, tell us that this statement is false, and that in fact this other, contrary statement is in fact true? I feel like I would be able to do that. But that's an interesting idea, to do that, especially when the damages are so minimal.
But see, in Florida, for example, there is a proposal, a judgment proposal. There's a system by which you can collect attorney's fees on all civil litigation. And I forget what it's, 'cause it's been so long since I've done civil, thank God. But so the problem is if you lose, you end up paying attorney's fees. And these cases are very expensive to litigate. So attorney's fees need to be off the table. Now, I don't know. I mean, I don't know what the answer is here. Yeah. I'm just describing the state of affairs in the system. Now, that's what we had up until pretty recently. But pretty recently now we have corporate suppression of speech. We have active censorship, government collusion to censor its citizens. And when the federal government is colluding, the institutions themselves that are meant to protect us are colluding against us. So we're in a very difficult state of affairs.
So, yes, I think we are. And I keep coming back to, like, I had no idea that the freedom of speech that was being discussed in the First Amendment when the First Amendment was first ratified was that you could speak all you could or all you wanted to, but it didn't prevent the government from punishing you if you overstepped that whatever bounds that the powers that be determined. That was brand new. I never knew that was the original position, and now and then.
Well, there's a problem here, and there's a problem with what you're saying there, and it's this stuff. The more you dig into it, the more complicated it becomes. And believe me, Brian Murchison made this very apparent. It was like it was basically my whole semester just in this class. I mean, that class was so overwhelmingly hard. And one of the things we're talking about here is punishment for speech and prior restraint. So there's a different standard, what you're pointing to, about the ability to speak, and then sanctions for speaking. So can the government prior restrain you from speaking? And if not, can they punish you for the speech after you've said it? And those are two different questions. So there's a lot of ice poured upon prior restraint.
Now, speaking of prior restraint, now we have a fundamental concept built into the First Amendment, even if you want to go back to the originalist idea that there is no such thing as prior restraint. So is the government justified, and I say the government in its broadest terms, including the courts, from gag orders in cases? Because I have a big problem with gag orders. I do not like.
I do too, but it exists, and the judges have the power to enforce the courtroom decorum, right? But is it a fact that our judiciary being politicized is a political issue, which is at the highest, the peak of the mountain when it comes to protected speech in the marketplace of ideas? And isn't a gag order saying you are not to criticize me, the judge, isn't that very thing a prior restraint on political speech? So that to me implicates the highest protection for First Amendment law.
And Joe from Good Logic briefed that out very well and filed it in the Trump case. I didn't read it all the way through, but
the fire in the crowded theater that comes out of Wendell Holmes, and but see, the thing is yes, we don't want somebody creating riots and panic situations. That's a dangerous situation. But if there's actually a fire, we want to encourage it, right? So it's sort of an interesting little thing that people know, but it's a lot more complex because it says it's illegal to yell fire in a crowded theater. But what if there's a fire in the crowded theater? You do want that to be said.
Well, and that's the thing. So he says famously he compared the leaflets to falsely shouting fire in a crowded theater, which was not permitted under the First Amendment. So that was in the the first case that he where he wrote the opinion on originally and wasn't dissenting. But the issue, he wasn't saying like that is fundamentally illegal, because like Steve said, sometimes it's not. If there actually is a fire, what if it's a joke? What if you're I don't know. There's a ton of scenarios.
Here's a little criminal, like criminalizing conspiracy to commit murder. Okay, well, that is something. You have an agreement with somebody, and we're going to go kill somebody, and we have an agreement. You go get the gun, and I'll get the ammo, and you get the gun and get the ammo, and we're going off to kill somebody. We haven't done anything wrong except for the agreement to commit the crime. The conspiracy, the agreement, the words, the speech is the crime. So that's a problem. Now, a problem with that, but the problem with that is now we have issues like in Michigan, I think, where we're in Michigan, where people are conspiring with government agents themselves. So you have somebody who is an individual who is communicating to the government their conspiracy. So can you have an agreement with the government to commit an illegal act?
Well, as we saw in the Whitmer kidnapping case, yes.
Yes, that's right. Can. That's right. So now we have activist police agencies, FBIs and other lettered agencies that are going in, and it's like everybody in the room's FBI and Fed, except the one guy who's in there showing up saying, "I'll go bomb something," right? And then they nail that guy. So it's like you go to the meeting of all. So who's who? I mean, do we want that kind of? Is that? I don't know. I mean, how much activist luring is going on? There's an entrapment idea. There's a creating the crime idea.
So Oliver Wendell Holmes says, in many places and in ordinary times, meaning not in war times, and you're not, distributing leaflets to convince people not to, or to convincing people to avoid the draft. The defendants, in saying all that was said in the circular, the leaflets, would have been within their constitutional rights, but the character of every act depends upon the circumstances in which it is done. The most stringent protection of free speech would not protect a man in falsely shouting fire in a theater and causing a panic. So that's the quote. The whole, shouting fire in a crowded theater. It does not even protect a man from an injury against uttering words that may have in all effect a force. So what he's alluding to is that context is required when we're talking about anyone's exercise of free speech. Now, this is the one where he upheld the conviction and he wrote the
But
opinion.
that's
He
the
would
problem.
later change his mind 7 months later.
But if context matters, and it does matter, we don't live in an absolutist thing. And also there's other
Right.
constitutional rights. So you can just put rights against each other. Now, I think that so there's a couple concepts we need to walk away from this discussion. One is that political speech is the most valuable speech. That is the decisions about debating the direction our country goes and the laws that exist and the laws that should or should not exist, speaking out against government action, speaking out for change, discussing policies about change. Those are the type of things that enrich the free marketplace of ideas. Truthful opinions, truthful statements, and reasoned opinions in a reasoned debate should be absolutely protected. It's when we start falling off, where the problem is people don't see these distinctions. This is like lawyer fuzzy thinking, but this is what we do, right? Is when we start talking about cigarette ads or pornography, or even worse, child pornography, right? Those are lower levels. We keep lowering down the level. And so those things, but people get them confused in their heads and they start thinking, well, then I should be able to go do this. No, what we're talking about, what's precious, is the ability to speak truth to government, to each other, and to make the country a better place, to thoroughly debate ideas and issues within the country. That is precious, and that's what the First Amendment, at its core, is meant to do, is to keep the government from imposing its opinions on the people.
One thing that we forgot to mention that a lot of people somehow get confused about: you don't have the right to free speech in all situations, meaning we're talking specifically about government action, either prior restraint or punishing you for your speech. It doesn't apply to YouTube. It doesn't apply to corporations. It doesn't apply to things like that. You don't have the right to go into a Target and just start spouting off stuff, right? We're talking about the right to free speech is protecting you from the government, not private entities.
However, as we well know, there is collusion between the major institutions and government. So, and that means streaming platforms, Facebook. And that's one of the reasons the Musk takeover of Twitter, now X, is very important, because I don't believe that he's trying to separate that platform. But most platforms are dominated by one ideological bend and actively suppresses speeches of people who disagree. There is a narrative that is generated, and anything that disagrees with that narrative gets rolled over. And I'll say it happens on the right too. We just don't have the mouthpieces. People, when I say something that disagrees with the conservative narrative, the conservative media doesn't want to hear it. They don't want to pick it up. And a good example is the Mendez case, right? The Mendez case, like, I'm for the wall, I'm against illegal immigration, and I think that's a big problem. It's a major problem. We need to address it. We need to have a vetting. But the Mendez case had nothing to do with that, right? You know about the Mendez case. And yet the conservative media was trumpeting their thing about illegal immigrants killing cops. And so it's like, that's the focus, and that's the narrative. And anything that disagrees with our narrative, we're going to ignore or falsely characterize. So I think it's this, I don't know, I'm just using that as an example. We got to break the narrative. That's why this kind of platform is important. But I'll tell you, the whole YT, that's why when I started this whole thing out, I primarily went on Rumble. Hi, Rumblers.
Because I'm on Rumble too, I think, but I don't know if anyone's watching. No,
well, I'm
no, I didn't set it up.
I'm streaming to Rumble, so I see this. Whitey Pie, job well done, Ghostery, they're all over. Because I think they're at least a little bit more favoring the type of speech that I favor, because I want to be able to talk about, shots if I did, or things that I want to talk about and not have to worry about getting my channel completely shut down. Right. Without appellate rights.
Joe from Good Logic has brought this up a couple of times in a couple of streams I've been on him with. Do you believe that there's a difference, or is it the same when we talk about the right to speak and the right to be heard? Meaning,
right. Okay, and that's another good point, because there is no right to be heard. Now,
right.
I'll this is all, personal, but I think I have some good books here. Okay, I think I have something to say, and I think I'm a moderately good writer. So I think that if you read my book, you'll enjoy it, right? Whichever one you pick. But I went to this book conference last Saturday, and I sat around, and there was all these freaks talking about their books, and it was all memoirs of their victimhood. How
And
they
you're
were
like, oh my God, I'm one of them.
Yeah. And I'm like, and I guarantee you that they're not well written. Now, I kind of had a little sympathy for the agents, because how many hundreds of manuscripts are getting submitted that are terrible? And all those people think they're writing great, brilliant stuff. And so do they have a right to be heard? I mean, it's like, I don't know. I mean, why is my book worthy of being heard and theirs is not? Well, I think there's a qualitative difference, but how do I know that? Isn't that up to the marketplace? So on the one hand, to get into the institutions, to get into the publishing industry, I'm a conservative, white, Christian, straight male. Boy, I was like hated. I felt the waves of hatred coming at me, like, you're not welcome here. And I guarantee you, those are the same people that are vetting my book up at the big institutions. But in order to get on in the platform at Costco, I've got to be fitting in their little category. So I am getting systematically excluded from the marketplace of ideas because of my ideology, regardless of the quality of my work.
Okay, so now let's assume instead of Costco, we're talking about a governmental entity that publishes all books, because we have to be talking about the government. Now, if the government says, nah, we're not going to publish your book, or better yet, the government goes to YouTube and says that MLS God of Law guy, you need to take down his channel. Do I have a right to be heard on this platform, or can the government say such a thing?
Well, it's not the government. See, this is the thing. Google is not. Now, there's two things with Google. Can I speak since you're not monetized?
Yeah, go for it.
One is, I think it's a monopoly. It's antitrust. Antitrust law, if we had a function, the problem is that the big corporations have fully captured the antitrust department of the Department of Justice, and there has been no legitimate antitrust enforcement for quite a long time. Teddy Roosevelt, who appointed Oliver Wendell Holmes, was a big trust buster because he distrusted corporate power. When Eisenhower talked about the military-industrial complex, he was talking about the over-concentration of corporate power as a threat to freedom. And so when it comes between my republic and corporations, I'm for my republic. I am for freedom. I'm for the people, individual rights. Now, that being said, so the antitrust law, second thing is there also needs to, and I don't really have the great answer, but I do think that these type of services, like we are on now, are really utilities. When you have constitution, it's like the power company. Can the power company shut you down because they don't like your beliefs? What if you're a Nazi? You have a right to have power, water. Can you have a phone? Can the phone company, Apple, can they take away your Apple phone because you're a Nazi? Right? Or whatever.
Well, the government's always slow to act, and they created the utility system when the power when electricity started running through. They created that, and then, well, a little bit before. Well, no, I mean, kind of right around the same time. They started with the telegraphs. They made that a utility, and it's probably a stretch from the railroad systems and things like that, which all involve private entities working with government agents.
Valhalla.
But they never got there with the internet, because the internet, they had the net neutrality law, right?
Valhalla Awaits makes a good point about the banking, because they are taking away people's right to bank. Now, I'm not a smoker guy, but though that's a cash business because of the federal laws. But what about gun manufacturers? The federal government is actively going after the ability of gun manufacturers to bank and to get financing in the system. It's called Operation Choke Point. And so can they take away my right to bank if I have politically incorrect speech?
They do that with so if you don't know, Michigan passed medical marijuana maybe 10 years ago, and then maybe 5 years ago, recreational. And the biggest hang up to people getting into that industry, because I actually looked into it. So there was like 3 different parts of it. You could be a grower and sell, or just one or the other, or you could do transport, or you could do testing at a lab facility. So those were like 3 different things. And I was like, I'll get a fleet of crappy white vans and transport it around. That's where the money's at. That's what I was thinking. The problem is if you're involved in that industry at all, you can't get insurance because they're federally regulated. So you have to have a certain amount of cash on hand to self-insure. And who has, $100,000 just lying around that you can put into a CD to cash insure yourself? So you can't get insurance, and then you can't bank with it because of all the federal regulations with regard to that. So yeah, that's a good question. And remember, money is speech, people. So
right.
says
So
the Supreme Court.
There is all of these things. I really do think it's a huge problem, and it needs to be. I don't know. I mean, what's the answer except for regulation? Competition is, but when the antitrust department is done and they aren't doing any kind of enforcement, we are allowing monopolies to conspire to shut down speech of political opponents. And that should be, they should eviscerate these companies that are doing that. But the feds are captured by the same institutions. It really is a big, big problem. And I think so the free market should correct. So for, example, Rumble exists, and Rumble is expanding and thriving because of Google's tyrannical policies, right? However, it's still the fact that Google runs these alphabet companies, and one of them being YouTube.
Yep. And so is Rumble really a competitor to YouTube? It's like your local pop company trying to compete with Coca-Cola. I was trying to think like we have RC Cola and we have Fago in Michigan.
I don't think that's a good example. I think the power company that's why I think there has to be some sort of utility, because their alternatives are, if you get a big here's one thing that and I'm a free market person, is very much pro. Okay. I'm very pro free markets, but free markets eventually resolve themselves into monopolies. Free markets are not perfect. Economically, that's the game of Monopoly was an example of that was created back in the trust era under Teddy Roosevelt, the game of Monopoly, to demonstrate the flaws of free market economics, that people will eventually gather up the resources in their own hand, in a few hands, and everybody else will get shut out and monopolies will naturally occur. So the game of Monopoly, eventually the board gets so tilted and the game just becomes unfun because one person wins everything. That's what was a result of free markets. And that's what the game of Monopoly was created to illustrate, and the antitrust blowback under Teddy Roosevelt. Now, we've lost that. We've lost that enforcement ability. So I think that we need to have vigorous antitrust enforcement. Number 2 is I think replacement for that is trade associations, nonprofit trade associations, who can establish rules that we all agree by. So it's a collusion necessarily, but it's one in which there's no profit involved, wherein companies can agree to certain standards, all right? Standards that are not private, but are in fact universally shared. Same thing with the utility concept. I don't want somebody shutting me out of my utilities because of my political beliefs. And I think there are these concepts that need to be leveraged in solutions. But when the thing is our debates are so poor, we're so drowning in lies and talking about all the problems have so overwhelmed us that we can't even have rational discussions anymore. And so I don't think
the other thing with that, monopolies are easier to come by because for some reason the federal government has decided that companies can't fail anymore. That's another problem I have too.
Oh yeah, exactly. And Mitt Romney, sorry to say this, I'll bring up his name, but Mitt Romney said something smart when he ran for president. And that was when I think it was GM was having all kinds of problems, and he got roundly criticized for it. But he said, what should happen? It's like, well, it should go bankrupt. The company should go bankrupt. It should be redistributed, broken up, sold off to the highest bidder and its component parts, and become more efficient. But what instead we chose to do was subsidize the big corporation on the backs of the little guy taxpayer, just so that it can be big. That's not efficient. Monopolies are not efficient. The argument for free markets is that they are efficient. And when we have these big corporations running things, they are not efficient. And so they need to fail, be redigested by the institutions, to be respawned. And maybe GM should be 5 different companies. Chevy, and have one Chevy, have a Buick, have a this, and a GMC, and those are different companies, and then they can compete. But instead, we've chosen to prop up, so it's too big to fail. If it's too big to fail, it should be broken up under antitrust.
Yeah, it's too big, right? If it's too big to fail, it's too big.
So we have a government infusion into the marketplace to prop up an institution that should rightfully fail, but instead it's taxpayer subsidized inefficiency. That's where the market, if it's too big to fail, it should be broken up. That's flat out. This is whenever I want to agree with my leftist friends, I start talking antitrust law, because I think it's way neglected.
Yes. We come a long way from Oliver Wendell Holmes.
Yeah. How did we get here? Where are we? Why am I here? Who am I?
Well, this is the natural progression that Oliver Wendell Holmes set in progress. That's essentially where we got to here. The point I really wanted to make with this stream is that the First Amendment, as we understand it today, with regard to the right of free speech, never existed until Oliver Wendell Holmes started talking about this.
Well,
look how far we've come.
Statement, my friend. I think.
Well, it didn't exist in American jurisprudence. It didn't exist in American jurisprudence.
Let me rephrase that. The modern era of First Amendment jurisprudence began with Oliver Wendell Holmes' dissent.
There you go. All right, fair enough. There you go. That's where we're at. Now, are we seeing a track backwards? Is like the second part of this conversation, and I think we're seeing it. I think we're seeing a track backwards, where the government is now starting to get more and more involved in punishing people, either directly or indirectly. Now, if my post about COVID gets taken down by Facebook at the government's direction, am I damaged? Do I have redress?
No, you don't have redress. This is what we have learned, is that all of these institutions have been such that there is no redress to violations of our constitutional rights. Our constitutional rights have been narrowed and narrowed and narrowed, and put in such a box by government actors using various arguments, to the point that I really feel that we don't have constitutional rights, really. And I know that that's a hard thing to say and to admit, but that's what I'm seeing. I see it in every constitutional amendment. It's not just the First Amendment. It's every one of them. And it comes, I was on the bleeding edge because I represent impoverished, poor public defender clients who don't have a political voice, who are the least of the least. And those are the people that are being subjected to a stripping of their constitutional rights. And then it says, well, who cares about that guy? He's just this. He's just that kind of criminal. Who cares about him? It's just a little guy. And then all of a sudden they start going for our political leaders or you. And it's like, what happened to my rights? Well, we surrendered them at the bottom level, and the government used that as a way to undermine the Constitution. It's a real problem.
Well, we could go down the Constitution road a lot longer than we have time for in this stream.
Today we're talking First Amendment. Let's zero in.
Today we're talking First Amendment and sailboats. It says freedom of speech and sailboats. I wasn't planning on this being a terribly long stream. My wife's coming home shortly, so I wanted to stream a little bit though, because I've been thinking about Oliver Wendell Holmes and the motion he set with his dissent in 1919, and how far we've come, and maybe how we're starting to see a pushback on that. And I'm not a fan of that. And thank you very much, Steve, for joining me to discuss this, because it's way more enriching when you're here. But I wanted to, Steve, are you a sailor? Do you sail?
You know what, my friend
Florida,
Derek,
man, you gotta sail.
Derek, my friend Derek, who is in Prepare. He passed away about 18 years ago or so. Always had a dream of being a sailor. And my friend Chris and Derek and I are very close friends in law school. And he always had this dream of sailing. And so the three of us would get on a sailboat and sail the Caribbean. I would say that my place in that equation was a swab on the deck.
All right, fair enough, fair enough. So, if you guys don't know, I do sail. I have several boats. Most of them are small, but I'm building my own sailboat. And before I started streaming, I would watch most of the stuff that I watched on YouTube, besides Steve Gosney, of course, was sailboat videos. People that would sail around the world. But there's a couple that are actually building their sailboat. I'm building a sailboat as well, and so I got inspired by these guys. And this is one of them that I wanted to talk about. So this is Samson Boat Company. This boat was built in 1920 something. And it's an amazing boat. I'm trying to pull up an image of it. But this guy's been streaming on YouTube for a while. I'm trying to go back to, there was a video I pulled up. But he's been working on this boat for a couple of years now. He bought it for $1, and he's been slowly restoring it. It's almost in the water now. It's in Washington, the state of Washington is where he's got it. Sorry, I'm trying to find. He's got this video on the history of this boat, and I kind of want to show it to you in the heyday. I have no affiliation with this guy whatsoever, other than I just watched him for many years building this boat. But this is so this is the boat. It's called Tally Ho is the name of the boat, and it's actually won some races around the world, races and stuff. And he wants to fix it up and then sail it around the world again a few more times. It's just a really beautiful boat, and they work off of everything is like donations. This is guy, he's English. You can
at the Royal Ocean Racing Club in London.
Yeah, see, so he's English, obviously. But he's been living in Washington, restoring this boat for a number of years. And the reason why I wanted to bring it up is it's a really cool project, and they're kind of running out of money. And so if you guys are at all interested in this sort of project, first of all, I'm not going to ask you to just give money to some random person, but go check out this program or their channel and check out what they've been doing. It's really cool. And I just wanted to promote them a little bit, although they have way more subs than I do, but this is a different,
Can I make a
YouTube. We're all in different, like,
I got a promo.
world. Yeah.
Since we're talking, and somebody that doesn't have very many subs, one of my Rumble subscribers, Slidey Pie, is she has a little channel, tiny little Rumble channel. It's on Rumble, and she is actually reading my book, Death Penalty Desires. She's already gotten to the first part, so she's reading the R-rated version. Embarrassing to me, but she's reading it on her channel, and I'm very flattered. And she's doing a great job. So she's already done first 2 parts up to the crime, and she should have another one coming out tonight. So if you've got you could go look up Slidey Pie. She's in Rumble Chat, and check her out reading Death Penalty Desires, which is available at stevegosney.com, my newest novel, as well as all the other books. So anyway, I think I'm very flattered that she's doing that. So there's a little plug.
Well, put the link in the chat so everyone can get at it, or is it already in there? But I absolutely love this boat. I am in love with this boat. Everything about it. I want to sort of recreate this thing, but just look at the beautiful mast. This is all handmade, people. This is all handmade the old way they used to do it. And it's just they're putting in the bowsprit right now. So check him out. He's it's just really cool. I inspire to have this in my life, and so I just wanted to promote that a little bit. That's all. Did we put your friend's Rumble chat in the? Oh yeah, there it is. Okay.
Jacob Castro did it over on Rumble. I see.
Excellent.
Maybe we could put that in the. Can you do that? Let me see. Copy.
Yeah, I got it.
I'll put it in private chat. You can do it if you want.
Yeah, please do that. Yeah. Okay.
Yeah. So go and get. She's only got like 100 subscribers, but she's reading it. It's kind of cute. I mean, I'm just flattered somebody felt well enough to read my. Yeah, there she is. See, look, see, she's already got the first one up, and then the second one, part 2. Nice. That's Slidey Pie. She's over in Rumble Chat right now.
Oh, very cool. Excellent. Yes. So go check her out. I will put it in the description as well. So if you guys are coming back, I'll put Steve's link, and then I will put Slidey Pie link in the in the description so you guys can all check it out.
Yeah, well, thank you for the invite, because I like I said, I'm kind of on hiatus. I got a lot of balls in the air, and I'm always going through these ups and downs and reassessing where I am and what I'm doing. But occasionally I'll get a nice invite. Somebody remembers that I exist and invites me on their show, and I appreciate that. I am the intrepid reporter for MLS Law, so
that's right. That's right. You still have the media pass.
I do,
if that trial ever happens.
There's my media pass. Look at that.
That's awesome.
MLS Law. You see that?
How old is that picture, by the way?
Oh, it's brand new. What are you talking about? See?
Okay. Sure. Thank you very much for joining me. Thanks everybody in chat. I don't know how regular I'm going to stream. Steve, you have anything coming up, or you just kind of like me, just like whenever inspiration
I'm
fits?
quite on hiatus. I will be appearing at a bookstore in Ormond Beach, Florida here end of next week. So if you go to stevegosney.com, go to the events page. So the only thing I have scheduled is that. I've got a lot of things going on in my life and in my world that I need to kind of I have to clear my mind a little bit. So I haven't been really streaming as much. But this was an opportunity you invited me on, and I streamed it on my channel too. So, keep the content coming as best I can. I don't like to do anything unless I have something to say, or I can give you my best. And that's what I'm trying to do.
No, I appreciate it very much. Solomon. Oh yeah, I see Solomon in the chat. Excellent. And guys, go check out Solomon Says. If one of the mods can put that in there, that's Solomon Anderson's new channel. His only live streams have been with me, but hopefully he'll start producing his own content. But everyone needs to go check that out, because we had a great run talking about Zachariah Anderson. And I will, I'll just see you all on the next one. Take care, guys.
When I was young, my